We've been here since 6 in the morning praying for a miracle. We decided that tonight at 9 p.m. we will have to take Katya off of life support.
3 college students, all full of life, with their full lives ahead of them, are dead. That video is per KOLD TV. They were struck as they were trying to cross a street just a few blocks from their university.
I'm not trying to, in any way, take away from the seriousness of the offense, but my client got scared, didn't know what to do, left, went to his apartment, communicated with his father, and walked back to the police station.
And just wait until you hear the driver's side of the story. That is the alleged suspect's lawyer, hired by his dad, who used, quote, significant resources, talking in court. The driver, police say, is also a college student, allegedly speeding in a Porsche, who, after crashing into those 3 people, taking their lives, he didn't pull over. He didn't do anything to help. He allegedly drove away so he could call his dad. What else his attorney said about his family's background in an emotional court hearing. We're on the case, presented by Law&Crime. I'm Chris Stewart. Boy, there are a lot of emotions that you feel in this story. And honestly, I just feel for the parents of the victims. They got the phone call that no parent wants, that call in the middle of the night, that their children were hurt and lost, allegedly at the hands of someone who decided that it was better to think about his own situation than theirs and sped away.
I believe strongly that Mr. Artal's reckless, thoughtless behavior and complete and total disregard for the law and human life demands the highest bail allowed and that he be remanded to custody.
Now, before I get into this truly emotional court hearing where family members of the victims, they were able to confront this suspect for the first time, I want to break down what happened just a couple of blocks away from the University of Arizona campus in Tucson around 11 p.m. on Thursday, October 30th. Now, I want you to meet 21-year-old Katya Castillo-Mendoza. She was an aspiring lawyer. And this is 21-year-old Sophia Troetel. She worked at the student radio station on campus. She also was a volunteer at the Pima County Sheriff's Office. And this was her boyfriend, 22-year-old Josiah Santos. He loved to perform. He often performed for the student theater productions at the U of A. So the 3 of them, they were just crossing a street. They were in a crosswalk near the corner of Euclid and 2nd Street, not far from campus. Now, the speed limit, police say, was 30 miles per hour. Now, you can see from this Google Maps image that I took here, we're not talking about a highway. We're not talking about a big street. This is an area that's lined with buildings and off-campus apartments, hotels, and restaurants. And yet, it's at that point, the suspect in this story allegedly sped through this area going faster than 30 miles per hour. Now, we have yet to hear exactly how fast authorities think this driver was going. Here are some pictures of the aftermath. These are images per KGO TV. Katya, Sophia, and Josiah, they were all hit by an alleged speeding Porsche. Here's what a family attorney for Sophia told the court in a bond hearing.
My understanding is there's also evidence that there was illegal substances in the defendant's bloodstream. So given the nature of this case, I think there's certainly a flight risk, and there's certainly also a community risk, which needs to be mitigated through either a completely elevated bail amount or remand with no bail. And that's all I have, Your Honor. Thank you.
So that's an important part of this as well. There is a belief that this suspect may have had drugs or alcohol in his system at the time that he allegedly killed these 3 people with his Porsche. We'll have more on that suspect in just a moment and the, quote, significant resources that his family has, and that's according to his own lawyer. Sophia and Josiah, they died on scene. One of Josiah's parents wrote on Facebook, quote, he sang, he danced, he acted, and every time he was on stage, I proudly whispered, that's my baby. They went on to say, and then came Sophia, another bright, beautiful soul. She loved him fiercely, and together they were unstoppable. Sophia had actually just turned 21 a couple of weeks ago. Katya was rushed to the hospital. Her family would tell the court that she died days later on November 1st. And they had to make the decision that no parent wants to make, no family should ever make. But they had to make the decision to pull her off life support.
We've been here since 6 in the morning praying for a miracle. We decided that tonight at 9 p.m. We will have to take Katya off of life support.
There is a GoFundMe for Katya that reads that she was one of the sweetest, kindest souls that you ever could meet, someone whose warmth and light touched everyone around her. Now, those 3 lives, those 3 futures, all ripped away allegedly by a speeding Porsche driven by a man who seemed to think of himself before them. This is video of that driver making his first court appearance. His name, 19-year-old Louis John Artal. And he's now charged with 3 counts of second-degree murder and 1 count of leaving the scene of an accident involving death. Now, he didn't show much emotion at this bond hearing that lasted roughly 20 minutes. He really just sat next to his lawyer and he listened to what the family members of his alleged victims had to say. He looked down a bit, listened to what his attorney was saying, and he had to listen to this. This is what the sister of Katya Castillo-Mendoza had to say in court as she says she was calling from the ICU after making the decision that her sister would be taken off life support.
And losing her has torn our family apart. We are completely broken. I hope he knows that he didn't just take her life. He took a piece of all of ours. We are begging, Your Honor, for the highest bond possible.
Artal was driving a 2019 Porsche Boxster. Those can run for around $60,000. Again, he's just 19 years old. We looked up the suspect's name on truthfinder.com, and as his attorney said in court, he has no criminal history. This is the first time he's ever faced serious charges, and now he's facing 3 counts of second-degree murder. Our partner Truthfinder is the powerful public records search service that we use to do research here on Law and Crime, just like in this story. It is a useful resource where you can plug in a name and you can get address information, criminal history like we were just talking about, and more. And it can also give you some peace of mind. It's one of the largest public records search services in the US, and with a paid subscription, you get access to unlimited reports of almost anyone in your area. When you talk about peace of mind, that includes looking up registered sex offenders in your area as well. Stay informed, stay safe, check public records with Truthfinder at truthfinder.com/OTC. Not only is he accused of having drugs or alcohol in his system at the time of the crash, but what makes this even allegedly more shocking, more disturbing, is what he did right after impact. His own lawyer laid it out during this hearing. Listen.
I'm not trying to in any way take away from the seriousness of the offense, but my client got scared, didn't know what to do, left, went to his apartment, communicated with his father, and walked back to the police station himself. He spoke to his dad. His dad said, go back, find the police station. I don't care how you get there.
Now, instead of stopping and getting out of the car and checking to see if the students that he just hit were okay, Artal sped away because he, quote, didn't know what to do. Now, it seems Artal's family has a lot of money. He's from San Francisco originally. He, again, was a student at the University of Arizona as well. His attorney that was hired by his family says that his dad owns an established business in San Francisco. At this point, we don't know what his dad does for a living, but the attorney laid out the financial situation in this hearing as an argument that Artal is not a flight risk.
Mr. Artal is a U of A student. He has an apartment here. His father flew in this morning and he is attending. He's watching this hearing. His father is going to, if Mr. Artal gets kicked out of the apartment that he's staying at U of A, he's renting a different apartment where his mom more than likely will move in with him from California to stay with him while he is here. There's absolutely zero flight risk. Mr. Artal is not going back to California. We're not asking for him to go back to California. There's no flight risk in terms of him attending every court hearing and every court proceeding. I will tell you that his father has allocated significant resources to retain our firm and to make sure that Luis is going to go to court. He's going to have family locally. There is the issue of flight risk is non-existent from my perspective, knowing the family, getting to know the parents, and meeting with Luis.
You know, there are cases where you see a defendant's, quote, significant resources actually used as an argument against them when it comes to being granted bond. But it's interesting because in this case, it's the defense arguing that those significant resources would prove that he's not a flight risk. Now, Luis's attorney also said that he was in the police station less than an hour after the crash. That has to be really difficult for the families of the victims in this case to hear, because when you think of the critical moments when someone is hit by a car and how long an hour is in that context, it's just something that you just find shocking, and it's a sad situation. And you hear the attorney also say, though, that Luis is going to face the consequences for his actions. We'll see what happens as this case continues forward. Now, Artal's attorney did ask that bond be set at $50,000. The judge decided that the bond will be $250,000 cash. If he posts bond, the 19-year-old will not be able to drive or consume alcohol or drugs as conditions of his release. Again, if he's able to post $250,000 cash, he also can't have contact with family members of his alleged victims. Join us now to talk more about this case is criminal defense attorney Eric Faddis. It's always great to have you on Law and Crime. First off, just watching this bond hearing, sometimes these, depending on the state, I feel like some of them are very procedural. You have an attorney make a statement and then go on. In this case, you had multiple family members being able to confront this suspect in court. How common is it to see a bond hearing like that just has so much emotion?
Oh gosh, Chris, certainly a sensitive issue, of course, an emotionally charged hearing, which is to be expected. 3 young people are dead, and their families are now kind of advocating on their behalf to the court, and they're trying to say, hey, look, this guy's bond should be high. He presents a danger. He presents a flight risk. On the other side, the defendant's attorney is doing his job, and he's trying to argue as to why a bond is appropriate, assurances he can give to the court. So, certainly a high stakes and emotionally charged hearing for bond.
I want to dive into a little bit about what the suspect's attorney said. Louis Artal, he is 19 years old. He was driving a Porsche, 2019 Porsche. From San Francisco originally. Per the attorney, his dad has a very established business that hasn't publicly been disclosed what it is, but the attorney said that his dad had spent, in his words, substantial resources to retain him as an attorney, and then goes on to say, that the mom would live with him in Arizona if he was allowed out on bond. And what stood out to me was in a lot of cases where you hear this defendant has a lot of money argument, it's typically from the prosecutor's side saying we need to have bond so this guy doesn't have a flight risk because he could get on a plane and get out of here. What do you make of the defense actually trying to use that as a reason that his bond should have been lower?
As defense counsel, and I've done both sides of this, I've been a prosecutor, been a defense attorney. Sometimes you have to show the other side of the coin. You have to take a fact that might ostensibly be against you and try to spin it into a positive. And so that's what defense was trying to do here. They're trying to argue to the judge that, hey, look, the resources aren't something to be concerned about, Your Honor. Rather, there's something to give the court assurance that he has the resources to defend against this case, to remain within the jurisdiction. He can apparently just get a house there if he wants and have his mom move in. Most defendants don't have that luxury. And so I think these were assurances defense was trying to give the court to advocate for a reasonable bond for their client.
And I know that bond the meaning of it is to make sure that this defendant is showing up to all his court hearings, that you don't have an issue of him actually being a flight risk. But I also think from a judge's perspective, had he said, okay, you have the money to buy a house in Tucson, Arizona, and your mom can live with you, and your dad's paying for your attorney, has substantial resources, like if the judge went along with it, there would have been backlash publicly because 3 young people are dead. What goes into a judge's decision? I mean, does that public pushback that he would receive actually factor into whether or not someone like Louis Artal would get bail?
You better believe it could, Chris, because, the judge during the hearing even mentioned how there were viewers electronically who were already watching the case that's just happened days ago. And there was already sort of national attention about it. So the judge has to be mindful of that. The judge does have a job to ensure that the law is followed, to ensure that they're not releasing somebody who could be a flight risk, who could be a danger to the community. And when you have this added pressure, everything is kind of magnified justified in a case like this. And so the judge is looking at it like, hey, not only what's the best decision in this case, but as a human being, could my decision affect me personally in some way? Could it affect how the public views me as a jurist? While that's not a statutory consideration for bond, it is a human consideration that certainly trickles into the mind of some.
This is just it's a tragic case. It's a horrific case. I think of the fact that you had this moment where the driver hits these three students. Who knows what he thought happened, but clearly he hit someone, drives to his apartment, calls his dad, and then the defense argues, well, he did come back. He went to a police station within the hour. And the argument also was he just didn't know what to do. I guess from a legal standpoint, and even for a defense attorney to say that he didn't really know what to do. I mean, I think as a human being, pulling over to the side of the road, even if you hit a deer, would be a good idea. How could that, I mean, how damning is that it's ultimately the defense is saying like, yes, he did this, but he just didn't know what to do.
Ignorance of the law is never a defense. But immaturity, naivete, those can be asserted as sort of mitigating circumstances. It's not the same as if a 40-year-old, did this and has all this life experience and might know better. Now, certainly the 19-year-old had a legal obligation to stop there, and we would all hope that is what would happen. Prosecution's going to have to prove a number of things. They're going to have to prove that the defendant sort of appraised the nature of the harm that he caused. Now, I don't know exactly what his mental state was at the time and what he observed and that kind of thing. Did he know those folks were dead upon impact? That's going to be difficult to prove what was going on in his head. I think defense is going to use this strategy by saying, hey, he was a young, dumb kid and this is a horrible accident, but it's not the same as like an intentional malicious killing. So they're trying to contrast from that type of case.
And the defense attorney did not push back, and it wasn't really the point of this hearing to push back on any of the facts of what actually happened. And I think the defense attorney did everything he was trying to do in this sense of like, look, I mean, very emotionally charged hearing, trying to get his client the best bond that he possibly could. But if in a bond hearing, you're not really denying that he was the person behind the wheel, and this wasn't really talked about, but it seemed like he wasn't really denying that he was the person behind the wheel. He says that he called his dad. Are you married to that defense now going forward based off what you say in a bond hearing if this was actually to go to trial?
It's a really important question, Chris, because that occurred to me too while I was listening to it. As defense, part of your job is to explore any potential defenses that may exist and any sort of plausible alternative explanations for what could have happened. And then it's the prosecution's job to disprove those in most states. So here, he's already kind of giving up the fact that he can't argue this was an alternative suspect. He can't argue this was another driver. And that could have been at least a possible defense to think about when negotiating with the prosecution by saying, hey, you can't prove it's my dude. Well, now they can. So you got to be careful about representations made to the court. But I think the defense attorney on the balance kind of concluded, hey, perhaps that alternative driver defense has no traction whatsoever. And instead, we should come to the court sort of hat in hand in an earnest fashion to try to, be straight with everybody and try to get some benefit from that type of approach.
I wonder, too, with the suspect driving away and the attorney said he returned within the hour. So let's just say like roughly an hour after the crash. And it was one of the victim's family attorneys who had brought up in this bond hearing that potentially he was either had been drinking or he was impaired in some kind. He's not facing charges like a DUI charge or anything like that involving drugs at this point. But the fact that he wasn't at the scene for an hour, if he pulled over to the side of the road, police officer comes up to you, they take a breathalyzer, they have a pretty good idea of what your blood alcohol level was specifically in that moment. I don't know when he had a breathalyzer or anything like that. Does the fact that he left hurt anything the prosecution could have about whether he was impaired at the time that this happened?
Well, it could be a significant problem for the defense, Chris, because in looking at the charges, there's a huge leap from just a sort of a careless driving causing death, where you aren't paying attention and an accident happens and kills somebody, and being intoxicated behind the wheel and sort of recklessly causing a death, which is a much more serious charge. But to prove that, what happened during that 1 hour interval is going to be very important. Oftentimes, not saying this happened in this case, but oftentimes a allegation will arise that a defendant sort of consumed substances after this event happened. And the argument usually goes, hey, they were freaked out. They didn't know what to do. Maybe they had a prior substance issue, monkey on their back, and they indulged in that because they were scared. And then what does that mean? Does that mean, how do you prove that the defendant was actually intoxicated at the time of driving and didn't get intoxicated at some time during that subsequent 1 hour interval? That's going to be tough.
As a defense attorney, and for the attorney for Louis Artal in this case, again, doesn't seem that they're denying that he was the driver who did this. But what do you do once you take this case, and even if it seems the prosecution has evidence that it was your client who's behind the wheel and all of this happened, what are the things you're looking at as this case goes forward? And you build your case about what your defense could be. How specifically in a crash like this involving a vehicle, what are you looking at?
There are a number of considerations you have to at least explore. Like you said, is there some kind of alternative suspect defense? Seems like that's out the window now. Is it possible that your client was not the one at fault for the collision? Well, it appears that the alleged victims were in the crosswalk, so that's going to be a tall order. On top of that, he has the resources. So what you would do is engage in significant mitigation efforts. I would do a mental health evaluation for this kid. I would probably do a substance abuse evaluation for this kid. I would see if there are providers who would opine that, hey, this is really out of character for him. This is a one-time instance, and he is not a risk to the community going forward. That is ammunition you need to try to develop as a defense attorney to use as leverage in negotiations throughout the case.
And part of this story, and he was driving a Porsche. And I think when it comes to a jury and they hear this case, here's a kid who's 19 years old driving a car that it was used, goes for about $60,000. That's much more than the average person. Well, car prices are going up, but let's just say for the average person, average 19-year-old, they're not driving Porsche Boxsters. Is that just the perception that this is a rich kid? As a defense attorney, is that something that you need to push back on if this was to go to trial? That he was, the rich kid that, he calls his dad, and then he's driving a Porsche that goes for $60,000. Like, is that a narrative that can have a negative impact on a jury for the defense?
Oh, I think 100%. And defense is going to have to try to get ahead of that because, look, a story that can emerge especially from the prosecution side, is that, hey, this was some rich kid who thought he was untouchable, who thought he was above the law, could do whatever he wants. He has this beautiful luxury vehicle, and he engaged in some wrongdoing and then didn't try to seek help, but instead tried to go protect himself by calling his rich dad, by enlisting an attorney very quickly. That can leave a very sour taste in the mouths of jurors, especially when we're talking about 3 young people he allegedly killed. So really important to try to get out in front of that narrative, investigate what sort of philanthropic contributions has this young man made, if any. What sort of redeeming qualities might he be able to assert to sort of level the playing field on that impression that the jury very well could have.
He's a college kid, 19 years old. If this becomes a civil case, if any of the family members end up suing him, obviously his dad's the one with the money, his mom's the one with the money, and this is just, I don't know how much money they have, just the attorney saying specifically they spent a lot of money to hire him. I would think that, he has this big business, I don't know what it is, but they clearly have some money. How, I guess, vulnerable would the parents be to a lawsuit if a wrongful death lawsuit is filed here? How does that work out?
So as a general rule, only the defendant driver would be on the hook for paying civil damages from the wrongful death suits. That would be times 3. There'll be 3 of them at least, or 3 of them. From there are some ways to try and attach parental assets. One is if the son shares any kind of investment vehicles that the parents gave to him, or is a named beneficiary of things like that. Sometimes those can be assigned. Some states have what's called a family car doctrine, and some states have claims for negligent entrustment, where if the parents let the kid drive this and he was having problems and they should not have let him do that, then there are ways to try and enlarge the settlement or jury verdict on the civil side, which could have a substantial impact on this family if the plaintiffs can do it right.
And I know this is one too that kind of goes from state to state, and in some cases, in this case, he's facing second-degree murder charges, but he was driving a vehicle. I think the defense could argue that he didn't set out that night that he wanted to hit and kill 3 people in a crosswalk. A lot of people with second-degree murder, it might be something in the heat of the moment he ends up shooting somebody, but in this case, it's a car accident. I guess, how does that differ from state to state, and why this wouldn't be like a manslaughter if he was driving, though speeding, hitting people in a crosswalk? It's not like it was his intention to do this.
Right. I think the second-degree murder charges are a bit ambitious by the prosecutor. I think that, you got to be careful about overplaying your hand. I reviewed the Arizona statute, and it appears what the prosecution was relying on is this extreme indifference murder concept, where they're saying, hey, he took actions with an extreme indifference to human life and recklessly caused the death of these 3 young people. Now, usually the typical example for that would be like someone, you're at a state fair and someone begins just sort of firing into a crowd. That's not an intent to kill a specific person, but it's a reckless indifference to human life and recklessly engaging in conduct that does kill someone. This isn't exactly analogous to that. I think what the prosecution is going to argue is that he got wasted and was speeding, and he should have known that that's a risk he could hurt somebody, and he did hurt somebody. But it's sort of a non-traditional approach to second-degree murder. We'll have to see if it sticks.
Yeah, we'll see how this plays out. Obviously, this is very early. We'll see what they find out as well about intent. We haven't heard anything about whether there was intent for anything. Not saying there was or there wasn't, but yeah, very interesting case, very sad story. 3 people losing their lives just outside the University of Arizona in Tucson. Eric Faddis, criminal defense attorney. It's always great to have you on Law and Crime. Thanks for being with me.
Great to be with you, Chris.
We're going to keep a close eye on this case. Artal is next slated to be in court November 10th for a preliminary hearing. That will do it for this episode of On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.